How are you doing? My name is Conrad. I'm a lawyer and a private law tutor. And today we are basically going to be looking at the topic of co-ownership. However, before we start on our class, I encourage you to subscribe to my channel. Just turn on the notification as well. And this will really help you so that every time I release classes, this is brought to your attention. And then lastly, before we start on our class, students that are really interested in private law tutorial sessions, please feel free to reach out to me. We will really be able to help you. If you're having challenges at school, you need private law tutorial sessions, just contact us and we can always arrange this on a private arrangement. And now most of the students who are on our private law tutorial sessions have been continuously proven to outperform their colleagues who do not have any sort of mentorship. So let's jump right into it. We are going to be looking at co-ownership, and in today's class we're going to discuss co-ownership in material detail. We'll define what co-ownership is, then we will also definitely look at the various modes of co-ownership or the types of land co-ownership. We'll also look at the constitutional legal framework within which co-ownership operates, and then of course I will also look at the various principles governing the whole concept of co-ownership. So let's start by looking at the definition of co-ownership of land. And basically when we talk about co-ownership, what we mean is that this is basically where two or more persons are entitled to the simultaneous use of land. So there are two or more persons, they could even be three or four. Basically the entitlement that they have to the simultaneous use of a piece of land in law is what is known as co-ownership. But it's also very important for you to know that actually there are different types of co-ownership, and that is tenancy in common and then joint tenancy. But however, before we look at those different types of land co-ownership, it's very important for you to appreciate the constitutional legal framework within which this concept of land co-ownership operates. And under the 1995 Constitution of the Republic of Uganda, specifically when you look at Article 237, Clause 1 of the Constitution, that article vests all land in Uganda to be owned by Ugandans. And then also of interest to you is Article 26 of the 1995 Constitution. That article in essence provides that land can be owned by individuals, either alone, individually, or it can also be owned jointly. Now, this article is of interest to us because under co-ownership of land, here would be looking at the simultaneous use of land by two or more persons. So Article 26 is really of so much interest to you. Now, it's also important to note really under Article 40 clause, Article 4, subsection 4 of the Land Act, it actually prohibits non-citizens from owning land in Uganda. So meaning that land in Uganda can strictly and only be owned by citizens of the Republic of Uganda. Now, having laid down that constitutional legal framework within which co-ownership operates, it's also very important to know the position of the law under the RTA, that is Registration of Titles Act, which actually provides under section 56, it provides actually for co-ownership. So the concept of co-ownership under the RTA is actually provided for very clearly, okay, and that is under section 56. Kindly go and examine that section further so that you're able to appreciate it. So let's jump into the various types of co-ownership, and there are basically two. The first type is tenancy in common, and then the second is joint tenancy. Now we are going to examine these a little bit more in detail so you can have a deeper understanding of each. And the first one basically is a tenancy in common. Now, what is a tenancy in common? Now here, tenants in common hold undivided shares, but they have quite separate interests. So their shares in the land are undivided, meaning that there are no clear demarcations that actually divide this land between these two or three more owners, but however they have their separate interests. Okay, now what actually this means is that death of one co-owner devolves his share to his successor. So where one of the persons actually dies, his share is devolved, it moves on, it is passed on to the successor, and that is under tenancy in common. Let's now proceed to look at joint tenancy. Now, under joint tenancy, this basically has two features. Joint tenancy, in essence, is characterized by two fundamental features, and both of them must always be available for us to say that indeed there is a joint tenancy. The first feature is what is known as the four unities. Now, when we talk of the four unities, here what we mean is the unity of possession, number two, the unity of time, the unity of title, and the unity of interest. We'll be looking at these unities later on a little bit more in detail. Now, the second feature of a joint tenancy is what we call the right of survivorship. Now, here, under the right of survivorship, property owned, okay, cannot devolve by will. When one of the owners passes on, okay, his share actually goes to the other. Now, meaning that under joint tenancy and under the future of survivorship, when one of the persons actually dies, they cannot pass on their share, okay, through a will to their successor or to their heir. They can't under joint tenancy. The principle is that that share goes to the other surviving persons, okay, under co-ownership. Now, there can't be joint tenancy without these four unities that we talked about. This is really very important. But however, let's examine them a little bit more in detail. Let's start by looking at the unity of possession. Now, this unity requires co-owners to possess possession of the whole piece of land. Okay, so if there are two owners, this unit is simply saying that both of them must possess the land simultaneously. I encourage you to look at the authority of Wiseman versus Simpson. It's a case of 1988, volume 1 WLR 35 at 42. And basically here, court held that one co-owner cannot exclude the other from the ownership of a particular part of the land. Both own the land in unity. That is the position of the law. Let's quickly now proceed to look at the unity of interest. And basically here, under the unity of interest, the extent, nature, and duration of each occupant's interest must be different, must not be different. So the moment it's different, then there is no unity of interest. Let's now look at the third unity, and that is the unity of title. Now, the unity of title has to be the same, okay? This is really important. It has to be the same, either by an act that granted the title or by the document that actually grants the ownership. I encourage you to look at the authority of Ward versus Ward. It's a case of 1871, volume 6, Chancery APP 789. And basically in that case, court held that all tenants must have acquired their rights by the same conveyance, meaning that the conveyance must be the same. The authority or the person that grants ownership, the power that grants ownership must be the same. The moment it's not the same, then in law we cannot say that there is a joint ownership. Then finally, let's look at the unity of time, and basically the interest of each must vest at the same time, and that is what we mean when we talk about the unity of time. Authority for that position, please look at the case of AG Securities versus Vahan, and that's a case of 1988, volume 3, All England Law Reports, page 1058. And basically in that case, the House of Lords went on to hold that there can't be a unity of time where agreements cover different periods of time, meaning that the agreements must cover the same time, because if it's not within the same time, then they are definitely under law cannot be a joint tenancy. So earlier we talked about the second element under joint tenancy, which is the doctrine of survivorship. Let's now interrogate this a little bit more in detail. Basically, the doctrine of survivorship provides that where one joint tenant passes on, his or her interest in the land automatically pass on to the other co-owner or the remaining joint tenants. Now, this is really very important for for joint tenancy to be in existence. The doctrine of survivorship must also apply, and it must be in play. Authority for that position, I encourage you to look at the case of Wilcox versus McLeroth, and it's a case of 1988, volume 3, All England Law Reports, page 1053. And basically here, court held that where the joint tenants die in situations making it uncertain which survived the other, then it shall be presumed that the younger survived the older. Therefore, the younger tenant's heir will be entitled to the legal interest in the land. In essence, court was trying to say that in case two co-owners, okay, die simultaneously, let's assume it's a road accident, the law will presume that the eldest died first and the younger died last, meaning that in essence, the heir to the younger will actually take the remaining share. So basically, ladies and gentlemen, that is really all about this topic. It's very important for you to always know the definition, to know the constitutional legal framework within which co-ownership operates, then to also know the position of the law or the authority that provides for co-ownership, which is section 56 of the RTA. Then it's also very important to know that co-ownership is actually divided into two, that is joint tenancy and of course tenancy in common. You have to know the definition of each, also know the authorities, but it's also really important for you to know that the joint tenancy actually operates on two principles, and that is the unities and the doctrine of survivorship. Know the unities, know how to define them, know the authorities, know also the definition and what really amounts to the doctrine of survivorship. That basically is what we had to look at in our class today. And once again, I encourage you, before I close out on my class, ensure that you really subscribe to my channel. This is really important to you, because every time you subscribe, also ensure you turn on the notification so that whenever these videos are released, this is always instantly brought to your attention. And also, of course, students interested in our private law tutorial sessions, please feel free to reach out to us. My contacts are down in the description box. Thank you very much. We meet in another class. Bye-bye.